All right, good morning and welcome to the 294th District Court. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Andrea Young. Motion for continuance filed by Mr. Thorson. Not sure if the state is aware of that. I believe Mr. Thorson had death in the family. Yes, the court indicated he had not filed a motion for record purposes. So Mr. Thorson, he didn't have to be here. The court's granting that. Is Ms. Young here though? Ms. Young, Amy Crocker. Here. Nicholas Fincher. Rebecca Hunter. Kiyoshe Knight. Kiyoshe Onigwa Knight. Court finds that they've been a 17-19 by the surety. Of course, going to be granting that, so I'm not going to be calling that. Claude Souls. Jennifer Zanella, waiver of arraignment. Year 8. Pre-trial said February 7th. All of this, they're all over. Jacob Stanford. Here. James Godwin. Here. Carl Stafford. Thank you, more. Charles Hare. Max Juarez. Daytona Blue. Espino. Tiffany Light. Tracy Jacobs. Jimmy Lynch. Dalton Trott. Right, and then Lionel Perez. All right. The duly. Yes. All right, and I believe that we have your interpreter ready to go. Go ahead and come forward, Mr. Perez. We'll go ahead and start getting you set up. And then at 9:30, I will call Miguel Castro. So anyone who's present in the courtroom, your name's not being called, you expect it to be called. Yes, sir, I can hear you. Yeah, Ms. Abraham was just now getting that set up, so she was like, all right, thank you. All right, court calls, cause number CR 21-389, State versus Perez. Court finds that Mr. Perez needs the assistance of the language interpreter. The court is going to swear in Mr. Perez at this time. Mr. Perez, you'll raise your right hand and state your name, last name for the record. All right, Mr. Perez, do you solemnly swear or affirm that you have made a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now trial to the best of your skill and judgment, so help you God. Mr. Perez, can you confirm, Mr. Perez, can you hear me okay? All right, excellent. All right, Mr. Perez is set for docket call today. Mr. Dooley, have you concluded your negotiations with the state? Where are we at? What's the defendant's announcement on docket?
Yeah, Judge, we have concluded the negotiations with the state. I'd like to put the offer on the record of 5 years deferred adjudication. And may I admonish my client before he rejects that?
Absolutely, yes, sir.
Thank you. Lionel, you understand that the state has made you an offer of 5 years probation? And you understand that the range of punishment for a third-degree felony is anywhere from 2 years to 10 years in the penitentiary? See, and up to a $10,000 fine? See. And sorry to speak over the interpreter. And knowing all of that, Mr. Perez, do you want to give up your the offer, reject the offer, accept this case for a jury trial?
Quiero ir a juicio, rechazo.
Thank you, Mr. Perez. Your Honor, we have filed all our pretrial motions, including a motion to suppress based on the stop, and it's the defense's position that we can run that with trials. It will not be a dispositive motion.
What's the substance of the motion to suppress if it would not be dispositive?
Sure, it's basically, well, it won't be dispositive from the defense side. It's basically challenging the contention of my client, Judge.
You want to carry that to trial. So typically, Mr. Dooley, I don't like to do that because it interferes with procedure of trial. I like to have all contested motions to be heard prior to trial, which are heard during an evidentiary hearings prior to docket call, prior to getting here today. So is that something? I understand that you have the right to carry it to trial, but as a judge, I get to control the docket, and I would rather have that hearing before trial so that when we start trial, we know exactly what we're dealing with, what we're not doing.
I'm perfectly fine with that as well, Your Honor. You run the court. I'm willing to do whatever the court says. I wasn't aware that we needed to have it done ready before today. I apologize for that.
So what I would propose, Mr. Dooley, is if you argue your motion to suppress that we set it for evidentiary docket, the next one I have available will be on February. Got one on January 30th. That's a week and a half. I don't know. That's enough time for the state to get its witnesses here. I think maybe the best move would be to set it on February 29th here for notice, so that the state can get any witnesses here they need to.
My calendar is clear that day, Judge.
All right, then what I'm going to do is I'm going to set the defendants. You said it's already on file. It's been provided to the state. Is that correct?
Yes, Your Honor.
Court's going to set this motion to suppress for hearing on February 29th. That'll be at 9 a.m. And I'm not going to make a decision on the docket call announcement until that day. So we're going to set a motion to suppress and docket call that day. All right, so that means your client's going to have opportunity to still accept this offer if it's being extended by the state past today. Obviously, the court can't control that, but if it's still extended through the motion to suppress, the court would be willing to suppress to enter into that. However, once we get past docket call, then the court's not going to entertain continued plea negotiation all the way up to trial. So I'm going to put a deadline on that. Expect that there's going to be a plea. It's going to get done by that deadline. If not, we set up a trial, then we're going to. So make sure you're on.
Do you understand what the judge has said?
All right, then Mr. Perez will see you back on February 29th at 9 a.m.
Thank you, Your Honor. May I be excused?
Yes, thank you, Mr. Dooley. Thank you, Perez. Mr. Castro Gobea here. Okay, that's fine. Is Mr. Alban here or anyone with Mr. Alban's office? I understand it could be someone maybe late. Do we know how late? Okay, Mr. Perez, do we have you for this hearing as well? How long do I have you for this? Let's do that because I don't think that he's going to be here within 10 minutes. So go ahead and sign off if you want to, and then I'll just look for something at 10 a.m. Thank you, Leonard. Yeah, seriously. Thank you. All right, counsel, do we have anyone else that's ready? Mr. Hawkins. Mr. Godwin, if you'll come forward, sir, CR 23-130. Alright. This is cause number CR 23-140-141, State versus James Godwin or Docket call. Go ahead, Mr. Watkins.
Your Honor, I had a witness statement that I obtained. I wasn't able to get it to the state until today. I had a scanner issue and then I was out of town when the weather hit, so I wasn't able to get it to the state sooner. I did get it to them this morning. I'm asking for a short pass, Your Honor, for them to allow them time to look at that and see if it makes a difference. So we'd ask for either a pretrial or whatever the next setting is, if that's possible.
How involved is the witness statement? Is it something that's going to take a lot of time to look into, or is it something the state can review this morning?
Well, I mean, they have it, Your Honor. I think they just need to look at the case a little bit and see if it flushes out. Is my opinion, but I won't answer this.
Not certain, Your Honor, if there may be a need for follow-up. For that reason, we would ask for another date.
All right, court's going to set a final docket call. Godwin. Offer to available on February 13th or 15th.
The 13th, I have a bench trial, Your Honor. You said the 15th?
13th or 15th.
15th is clear on my document.
15th is clear. All right, court sets Mr. Godwin then for final docket call on February 15th at 8 a.m. Once you sign and get your appearance, you're free to go.
Thank you, Your Honor.
Sir. Is that all you have, Mr. Hawkins?
That is all I have, Your Honor.
Appreciate you. Yes, sir. Mr. Moore, you ready? Yes.
Okay. That's good.
Court calls cause number CR 23-153, State versus Paul Wayne Stafford pretrial. Go ahead.
I'm sorry, Judge.
Go ahead.
We don't have any unresolved pretrial issues at this point. I've been visiting Ms. Burry. She is talking with the family of the deceased on this case, see if we can reach some sort of resolution. We do need a little bit more time to see if we can possibly avoid a trial in this matter, but we don't have any other pretrial motions.
Okay. If there's no pretrial issues, then my routine, my course procedures is to send it for a docket call about 30 to 45 days out. You know, it's Kurt, you need more time than 30 or 45 days to talk with the family on this case.
Yeah, Judge, if we could have at least 45 to 60.
Just want to say, check. Will you go ahead and check March 26th, see if you're available that day?
Yes, I do have some trial settings on the 25th. None of those are special settings, so. Assuming that I'm not in trial on the 25th, I'd be available on the 26th. I'm set right now in Panola County and Marion County on the 25th for trial, but I don't know that any of those are priority cases for that day.
Okay, let's do this. We'll go ahead and set, March 26th at 9 a.m. And if, obviously, if you're in trial, then you'll just let the board know, those continuance, we'll get you reset.
Yes, sir.
All right, once Mr. Stafford signs and gets his yellow notice, it's great. The other council that's ready. Yes. Yes. All right, this is cause number CR 23-4, state of Texas versus Dalton Wayne Trot for docket call. The board is going to set final docket call for Michigan Trot on February 27th. And once Mr. Trot signs, gets his bill of notice, the parents gives.
Judge, maybe excuse me.
Yes, thank you, Mr. Woodward, appreciate it. Any other council is ready to go? Schmidt, ready? Yes. Mr. Ward, so Yes, sir. All right, this is cause number CR 23-185-186, State versus Max, Alexander Juarez. Yes. Okay. Twelve 45 on CR 23-186.
I think they're working on that, Judge. Yes, sir. I'll print a new one.
All right, Mr. Juarez, who is your writing application of oath? Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Or you're gonna make sure you speak up loud and clear. Your name is Max Alexander Juarez, is that correct?
Yes, sir.
Mr. Juarez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No,
In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
yes,
You feel like you've had enough time to talk with your attorney about the case, have all of your legal questions answered to the point that you understand everything that's going on in court today and everything that you've read and signed?
yes, sir.
Mr. Schmidt, you believe your client to be competent,
Yes, Your Honor.
and you've explained to him his rights as they pertain to this case.
I have, Your Honor.
You also explained to him the advantages and disadvantages of a deferred adjudication plea.
Yes, Your Honor.
Do you believe that he understands all of the risks that he's entering into this plea agreement, intentionally, knowingly, involuntarily?
Yes, Your Honor.
All right, Mr. Juarez, I see that you are indicted with a state jail felony offense of possession of controlled substance and milligram two less than 1 gram. That does have a range of punishment of not less than 6 months in a state jail prison, not more than 2 years. And you could also be fined up to a maximum of $10,000. I see that the plea agreement in your case is that you plead guilty to that crime.
Judge, just to clarify, he's actually indicted for a second degree. It's being reduced to a lesser included state jail. You said he was indicted for.
Yeah, the judgment says that indictment and degree of offense was state jail felony. All right, so we're gonna do lesser included. All right, so Mr. Juarez, you're indicted for a second degree felony offense, possession of controlled substance in building room. Still 2.
4 to 400. The penalty group 2, 4 to
See, I don't know if any of this.
400.
Okay,
And I'm sorry, I didn't catch that.
no, that's. Let's back up and give you some different admonishments. Apparently, you were indicted for a second degree felony offense of possession of controlled substance in penalty group 2 greater than 4 grams, less than 400 grams. That originally carried a range of punishment, a minimum of 2 years in prison up to a maximum of 20 years in prison and up to a $10,000 fine. I see that the plea agreement in this case is that to a lesser offense, possession of controlled substance less than 1 gram, a state jail felony with a new range of punishment, a lesser range of punishment, not less than 6 months in a state jail prison and not more than 2 years in a state jail prison, and a possible fine up to $10,000. Do you understand the difference in those legal ranges?
Yes, sir.
I see that upon your plea of guilty to that offense, the state's recommending that the court consider the evidence, but and if it finds that there's sufficient evidence to convict you, that the court not not convict you today, but place you on deferred adjudication for that state jail felony offense and place you on 3 years of community supervision. Also assessing a $1,500 fine, ordering you to pay court costs and reimbursement fees and restitution. And as part of the agreement, there would be a weapon forfeiture related to CR 23-186, unlawful carrying of a weapon. In that case would be dismissed with your plea in this case. Is that your understanding of the agreement, Mr. Flores?
Yes, Your Honor.
Is that correct, Mr. Schmidt?
It is, Your Honor. I do have the 1245.
Okay, we'll bring that forward. Yes. All right, Mr. Juarez, understanding the range of punishment for the lesser included offense of state jail felony possession and understanding the plea agreement, how do you plead to that offense?
Guilty.
Are you pleading guilty to that offense because you are guilty of committing that crime and for no other reason?
Yes, Your Honor.
Has anybody threatened, forced, or pressured you to plead guilty in court today? Has anybody making you do this?
No, sir, Your Honor.
Are you doing this because this is what you want to do to solve your case?
Yes, Your Honor. Thank you.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, Your Honor.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial position. Is there anything further from the state?
No, Your Honor.
From the defense?
Rest in closure, Your Honor.
All right, what's your name? You have stipulation of evidence. Is the offense for what you convicted is marijuana?
It's THC oil, Your Honor. It was a couple of vape pens. It was just slightly over 4 grams of liquid THC.
Okay, can we amend stipulation to include that, because that's not included? It just says a vape cartridge at 4.48 grams. There's nothing in here about legal substance.
Yes, Your Honor. I'll amend it.
No objection.
We'll amend that, show it to the defense counsel. Defense counsel, I think, sign it. Yes, just whatever that is. Yes. All right, based on the evidence before the court finds that there is sufficient evidence to convict Mr. Juarez of this offense, the court will follow the plea agreement today. The court hereby refers to finding of guilt on the lesser included offense of state jail felony possession of controlled substance to less than 1 gram. Or places Mr. Juarez on 3 years deferred community supervision, orders him to pay a $1,500 fine, $290 in court costs, $35 in first fees, and $180 in restitution. Furthermore, the court dismisses under section 1245, cause number CR 23-186, unlawful carrying of a weapon. And the court finds that the parties have agreed to a weapon forfeiture in the disposition of this case regarding Juarez firearm as indicated in the judgment. Mr. Juarez, you're hereby granted to Leslie probation department so they can carry out the terms and conditions of the sentence. I'm going to come forward to be fingerprinted. You'll get it. Yes, let's see. Do we have any other councils ready? Ready, Mr. Espino or?
All of them, Judge.
All of them. Okay. Mr. Espino, the DR 21, 113, 114, and 115. I'll docket it twice. This is the final docket call for Mr. Espino, is that correct?
That's correct, Your Honor. We are asking for an open plea bench trial. We would like to have it in February to give us a little bit of time. This was a situation where we were cooperating witness and we're gonna be in front of you.
Correct. Remind me, is Mr. Espino already waived his right to jury trial?
I believe we can.
Oh, excellent. Okay. That's what I was waiting for.
Judge, I'll have to fill out the top of this.
On the schedule of the bench trial, where you. Why?
I was looking for the last part of February. Happily, the state has agreed that they didn't have a problem.
That's fine.
What are we looking at as far as the witnesses and time, parties that would be required for this bench trial? I don't want to set it on the regular evidentiary docket. If it's going to take half a day or.
I would expect it to take at least half a day.
At least half a day. He says half a day, that's probably half a day for him and half a day for you. It's quite a full day. Probably a full day.
And if it needs to go into March, I won't complain.
Why, what about February 16th? Okay. All right, the board says Mr. Espino will then draw on February 16th. And would it be a full bench trial, or did that you say open please?
Open.
So it's gonna be trial punishment. Yes. All right, Mr. Espino, if you'll read your right name, I'm gonna place you under oath and ask you some questions about this waiver. Mr. Espino, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, Mr. Espino, in this matter that you have pending in this court, you've been represented by your attorney, Mr. Jeff White, for quite some time, maybe a number of years now, correct? And today, Mr. White has indicated that you are making a decision that you want to set your case for an open plea and bench trial. And part of that means that you would be waiving your right to a jury trial. You understand that? And you understand that you have the absolute right to have a case trial for a jury of your peers here in Baytown County. You understand that? Mr. White cannot waive that right. I cannot waive it. The state can't take it away from you. You and only you can waive that. You understand that? And if you waive that right, you will not have the ability to put witnesses before a jury or have the ability to cross-examine witnesses before a jury. And once you waive it, if you do so intentionally, knowingly, and voluntarily, you may not be able to get that right. That's meaning that when we come back to court, you can't say, hey, now I want a jury trial. You understand that? You thought through this decision, is that correct? You discussed it with Mr. White, he's explained it to you as well, is that correct? And you feel comfortable about your decision today? All right, is there anything that you don't understand about what it means to waive your right to a jury trial that we can answer? Okay. All right, Mr. White, do you believe that Mr. Espino understands waiver?
I believe so, Your Honor. He's competent to make the decisions he's making today.
You join now waiving his right to jury trial.
I do, Your Honor.
Or we'll also note for the record that the state too is waiving its right to a jury trial in this matter. Or finding that Mr. Espino has intentionally knowingly voluntarily waived his right to a jury trial, accepts that waiver. And for it says Mr. Espino for open plea for Friday, February 16th at 9 a.m. Mr. Espino, once you sign and get the yellow copy, you're free to go. Thank you. All right, Tiffany Johnson White, CR 2259. Are we doing the big thing on this line? Is that
Your Honor, spoke with state on this. We don't have paperwork. We could have like 2 weeks to come back and have that done. There shouldn't be any problem. We've already got an agreement.
what was the issue that we can complete that today?
Your Honor, that it was just on us with the trial last week. I just forgot to make the request.
All right, the board will reset this line. You want February 1st? Thursday. It's Thursday.
February 1st be good.
All right, board sets this line, February 1st, honey. Yes, sir. Who do you want to call first?
Your Honor, I got one more.
Oh, you did. Sorry, I didn't see it. Yeah, there's this Daytona Blue.
That's correct, Your
All right, Daytona Blue CR 23-201. My apologies. I was looking down docket instead of. All right, Mr. Blue is set for pre-trial. Go ahead, Mr. White.
Your Honor, I have filed three particular motions that I do on virtually every case. State has showed no opposition to that. The only problem I have is I didn't get discovery until yesterday.
All right, we'll reset. Pre-trial on this matter. You want February 13th or 15th?
February 15th.
All right, court sets Mr. Blue for additional pre-trial February 15th. 9.
And Judge, I believe that is all I have.
All right, who do you want to call first? Tracy Lane Jacobs, CR 23.
Yes, sir. Could you please give me the cause number?
Yes, CR 23-00100.
Your Honor, we're gonna ask the court if we could put this on February 15th plea. I think the last time we were here, I informed the court that basically this is just a monetary issue. I think we've got all that money. I believe that, Ms. Jacobs came by my office this morning and gave me the remainder, but I've got to run that through my trust account, to make sure everything clears and all that.
And Ms. Jacobs, I want you to check in if you haven't already. I want you to check in with Mr. West, pre-trial release, make sure that you're honest, okay? So that you did your report for the end of December, and I want to make sure that things cleared up. Mr. West, are you good with Ms. Jacobs? Okay. All right, court says Ms. Jacobs will plea on February 15th. Will that be a morning plea?
Yes, sir.
That'll be set at 9 a.m. You need Walter Lynch. For CR 23-187, sets the pre-trial, but
Your Honor, we don't have any additional pretrial unless we'll abide by the court's standing order, ask the court to set this for docket call.
what that same 15th day.
Yes, sir.
All right, court says Mr. Lynch for docket call on February 15th at times. All right, I see what. Mr. Valderrama, we're just waiting for yet another interpreter. Mr. Ashton, are you ready? Thank you. All right, this is cause number CR 23-226, State versus Jacob Dean Stanford. All right, Mr. Stanford, if you'll raise your right hand, sir, and please show your oath. Mr. Stanford, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, your name is Jacob Dean Stanford, is that correct? Mr. Stanford, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with any comprehensive? Represented by your attorney, Mr. Casey Ashmore, do you feel like you've had enough time to talk to Mr. Ashmore about your case? Are you pleased with the work that he's done for you? Is there anything about the paperwork that you've read and signed that you do not understand? Mr. Ashmore, do you believe that Mr. Stanford is competent to interpret it?
Yes, Judge.
You've explained to him his rights as they pertain to this case, also the advantages and disadvantages of a deferred adjudication.
I have.
And you believe that he appreciates those risks that he is entering into this intentionally knowing.
I do, Judge. I've explained to him at length, both before today and today, that the deferred adjudication permits him the kind of golden opportunity to enter a plea of guilt, to have that finding deferred. And that when he successfully completes that period of probation, the court will enter an order dismissing this matter. And there's even a disclosure in there we covered that he might be eligible for non-disclosure, things of that nature, as well as the sanctions and how they're increasing in remedy up into incarceration, and that it's a 2 to 10 year sentence. And with this type of Chapter 22 assaultive offense, probably going to be something, even if it's not 3G, that he'll face a significant amount of prison time if he messes this up.
You agree with all that, Mr. Stanford? Yes, sir, I do. Okay. All right, Mr. Stanford, I got to go over some legal warnings with you. You are charged by indictment with a third-degree felony offense of injury to a child. Third-degree felony does carry a range of punishment of not less than 2 years or more than 10 years in prison and a possible fine not to exceed $10,000. The court finds that your plea agreement is that you would plead guilty to that crime in exchange the state's recommending that the court review the evidence. And if it finds enough evidence to convict you, that the court not convict you today, defer a finding of guilt and place you on 6 years of community supervision, so known as probation. You would also be ordered to pay a fine of $2,500, $290 of court costs, and reimbursement fees of $1,285. Mr. Stanford, is that your understanding of the plea agreement also? All right, then understanding the plea agreement and the range of punishment, let me also make sure that you understand. I think that you do, but I want to make sure you understand that if the court approves this plea agreement, place you on deferred community supervision, if during the period of your supervision, that's 6 years, if you violate any of the conditions that we read over and signed today, the state can file a motion to bring you back to court. And if the state proves to the court that you violated one of these, they could ask the court to do a number of things, including convicting you of this offense, making you a convicted felon for the rest of your life. Or the state could ask the court to revoke community supervision, means take you off community supervision and put you in prison anywhere from the minimum 2 years all the way to a maximum 10 years. That's an inherent risk that you have in this plea agreement. And if we have a hearing like that, there would not be any question about whether or not you committed the crime because you'd be pleading guilty to that today. That issue would be over and done with. The only issue before the court at the next hearing, if there is one, is did you violate your community supervision? And if you did, then what happens to you? Do you understand that? Yes, sir, I do. Okay. And understanding all that, you still wish to go forward? Yes, sir, I do. All right. Mr. Stanford, then how do you plead to injury to a child in 3rd degree? You're pleading guilty to that crime because you are guilty of committing that crime for no other reason. Does anybody threaten, force, or pressure you to or does accept the defendant's plea of guilt? Mr. Ashmore, any objections to the stipulation of evidence?
No, Your Honor.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial conviction. Anything further from state?
Your Honor, just that a victim impact statement was mailed out end of November and has not been returned. So state is in compliance on this case.
Thank you, Mr. Arlo. Anything further from defense?
No.
All right, then the court will review the stipulation of evidence. Right, based on the evidence, the court finds that there is sufficient evidence, really Mr. Stanford, will follow the recommendation of the state plea agreement with the parties, or hereby confers finding of guilt, places Mr. Stanford on 6 years of community supervision, orders him to pay $2,500 fine, $290 for the cost, $1,285 on reimbursement. Mr. Stanford, hereby retained into the custody of the probation department, so they carry out the conditions of the sentence. Have you come forward with Deputy Martinez? He's going to take you through. Drive on, you can solve this one. Sir. After those documents are issued. Just follow up with your file. Make sure that the interpretation channel is still set up correctly. I didn't unassign you, you left. I wanted to make sure that it still works. I didn't know if I had to end, start it back and create my channel. Right now, I showed that you're set up. I can't guess.
I don't.
Miss Abraham said, Mr. Gobea, that's me. place. While he's getting set up.
Hey, so Tony,
The interpreter in this case. Mr.
hey,
Excellent. All right, court calls cause number CR 23-166, State versus Miguel Angel Castro Villa. Should we were set for a docket call today. To be all that. Is that correct?
Yes, sir, it is.
All right, and Mr. Alderman, you've been here on every.
Yes, sir, I have. Yeah.
And if there are any issues that the court needs to be aware of, what's the defendant's announcement?
Judge, we're gonna request, another docket call. We have a expert that was hired. Got some of the discovery, some of the information over to him. We're waiting on the report that, I've talked to the state about this, and, we're waiting on the report because, it may affect the, plea negotiation process. So, I think we should have that report within the next 30 days or so. So I was requesting that if we could get one more docket call, that way I can get the report, get it over to the state, and figure out where we stand after that. That way we could be in a better situation and understanding as to what the next step in this process will be.
State.
yes, Your Honor, I'm overhearing conversations, like that does sound familiar. If they're expecting a report in about 30 days, I would request at least 45 to 60 days so that they have time to get the report to us. We have enough time to actually sit with it and review it, so that we can have an effective offer based off of that.
State's requesting 60 to 45 based on their 30.
Yes, Your Honor.
That would work with us, Judge.
All right, court says Mr. Castro will be for final docket call. That means I want the defense and state to have completed, if possible, their negotiations on that day, by that date, and then have an announcement of whether we're doing a jury trial, bench trial, or something like that.
Yes, sir. Okay. Understood, Judge. Thank you.
So that's gonna be March 26th, final docket call. That'll be at 9. President approach. Did have controlled substance.
Yes, yes, sir. I totally understand.
Yeah, I think I told him up front.
Yes, yeah, you're upfront with it, so I appreciate you, Judge.
All right, so he's set for 3:26. He just went to have a seat in the hallway. Mr. West will be with him in a moment. If he is negative on his drug test, then West let him go, will indicate that to me. If we have an issue with the drug test, then we'll stay here now.
Yes, sir. Thank you, Judge. Maybe be excused.
Yes, for now. All right, thank you, Mr. Morales. I don't think that we need you to explain any more. Being able to hop back on 10 o'clock. Thank you. Thanks, good seeing us. Thank you. Mr. Sanders, are you ready? Yeah. Right, this is state of the. Has to be reviewed.
It is.
And then use the small speaker and provide. Great. Will provide the speaker. Will arrive. All right, this is cause number CR 23-154, State versus Charles Ray Bear. Reach all, go ahead, Mr. Sanders.
Judge, we were able to get the videos from the state earlier this month. And we filed a motion to suppress. So I was going to ask if we could set this on the contested motions docket. If sometime in February.
All right, so any objections to the motion to suppress? Mr. Sanders is on generally one that files a boilerplate motion, but you lay out specific grounds and specific issues in motion to suppress.
Oh, yes, as far as the detention and the length of the detention and something. And Judge, I just filed this morning, so they haven't even gotten a copy of it yet.
Any objections to the board setting the dates?
In light of that representation, no, Your Honor, but I think it's my case. I've reviewed the discovery and I can understand his reason for filing it, but I think ultimately it will be boilerplate.
Or it says Mr. Hare for issue document.
Your Honor, may I request a different date? I intend on taking a day out off that day. It's actually my father's birthday every 4 years, so
We can either move it up to January, which would be Tuesday, the week of Tuesday. Otherwise, we gotta get to March.
March might be, I'm not sure as far as like, I know at the end of January, I've got a few things set that week. Maybe if the March date would be work, that might be best.
and so Your Honor knows I have not had a good opportunity to speak with Mr. Sanders about maybe working out a disposition in this matter. I'm certainly not opposed to that. We'd be happy to have that conversation.
All right, court says Mr. Hare's motion to suppress for hearing on March 28th at 9. Mr. Hare, I've got a note that you're delinquent on your pretrial release fees.
Yes, sir. I talked to Todd this morning. Told him I'll be able to tomorrow.
For how much?
For 120.
Okay. All right. Believe that you're a man of your word, so you give me a reason not to, okay?
Sir.
All right, once you sign the yellow copy. Oh, yeah, Mr. Chambers? Yes, do you have anything separate? No, I don't. Okay. Cause number CR 22-121 State versus Montreat Nicole Young. Told you Mr. Thorson had a death in the family.
Yes, Your Honor.
The board is going to, is granting this motion for continuance. We're going to set that on January 30th. That's the day that Mr. Thorson had requested, so. Just do that plea on that evidentiary day.
Sounds good. Thank you, Your Honor.
Oh. Wonder. All right, we're just gonna stand in recess for about 20 minutes of some paperwork I've got to review for the remainder of our hearings. So just check back in. It's 10:30, so about 10 to 11, make sure you're kind of back in the courtroom. We'll follow the remainder of the case. We're gonna stand in recess at this. Hunter. Come on up. All right, this is just a sanctions court hearing. Cause of CR 22, 2 weeks. Becky. All right, Ms. Hunter, let's see. Show that you failed to appear on November 28th. We're gonna talk about the missing probation payments, missing court collection payments, failure to work community service. So why don't you hear on?
I sent paperwork to your office from my physician. I had COVID. And I did talk to a lady here up here at the court. I can't think of her name right now, but I did send the doctors. Oh, and I also sent it to my probation officer.
Is that did you go to the doctor? So yeah, yes. Since then, have you been able to get caught up on your payments?
No, sir, I did pay the $168 that I was ordered to by the court. I got laid off of my job October 26th. I was in a severe car accident December 4th. I actually had brain damage and thoracic spinal injuries. And during that process, they gave me an MRI and they discovered that I have thyroid cancer. I just kind of through it. I did hire an attorney though for the accident, so I will get quite a pretty penny that I can pay it at all. I know that don't do much for my community service, but right now I'm doing therapy 3 times a week and I sent emails to the indigent officer, I think, up here at the court on my medical.
Have you talked to an attorney about disability or disability?
Not yet. I've been trying to get unemployment since I got laid off due to no fault of my own, but you know how the unemployment people are. They're fighting me tooth and nail. I haven't got anything documented yet about the cancer to claim unemployment or disability. So.
Okay. What I'm gonna do is this, Hunter, since you have provided this documentation on your accident, I'll let you continue to provide documentation to your probation officer. I'm gonna suspend you on sanctions for a little while, give you some time to try to get out. Are you gonna be in the building? The rest of it.
It's thyroid. Yes.
What is that?
I don't know yet. I just found out about the cancer. I did the MRI and they found a mass on my thyroid. And I did a sonogram and then they sent me for a biopsy and the biopsy came back positive for thyroid cancer. I do not have any documentation yet of that, but I will get it and I can send it to you.
I'll just send it to your probation officer. Probation officer.
Yes, sir.
So I'll tell you what I'm gonna do, Summer. I'm gonna reset you for. Okay, probation officer. Hey, what you can, if you get something worked out, take care of this. I'll bring you back. That's the third day that they need to figure out, so we do have a little bit of time. You don't expire until 2027, so I'm gonna put you on pause and get you medical issues, legal issues, or accident. So bring you back Thursday, April 18th. So that's have a status.
Thank you. Yeah.
All right, just remember, I want you to stay in contact with the probation officer. Just because you're not coming back here until April, doesn't mean, yeah, it doesn't mean you're on probation, it doesn't mean that you got to pass, so check in and do those things. Now, I'm not gonna bring you in and monitor you on this, but know that if you get these things worked out, then you just gotta start getting caught up on your community service. Basically, all I'm doing is getting costs today. You know, I'm saying I'm gonna resume in April. So all those things that aren't getting done, I'm just gonna push. Okay, all right, we'll see you back in April. Mr. Souls, I'm sorry. Go ahead, Souls. Amy Crawford. It's the same we're hearing, CR 0563. All right, Mr. Crawford, let's see.
I was supposed to pay, but I got sick. That's why I didn't make it to that one. I had RSV pneumonia that I've been trying to get over. But I am gonna start paying again this month. I'm gonna pay 50 to probation and 50 to the restitution.
That's the most that you can pay.
Right now, I'm still trying to get back from being sick.
What will you pay for your sick?
I think 70, 80. Yes.
And so I think we're gonna do on that, set you for February. Setup.
Okay.
And see, $50 for $50 to probation. $60 to work for January.
Yes, sir.
And then you go to, it says here that you're supposed to be paying 80 on restitution, 90 on probation.
Okay.
So for February,
Pay 80 and 90.
pay 80 and 90.
Yes,
So
sir.
1550 for January.
Sir.
And then February, 90 probation and 80 to your restitution.
Yes, sir.
Okay. Have that done before you come forward on 27th.
Yes, sir.
All right, they're gonna bring it, Saturday or something that.
Yes, sir.
Polls. All right, Mr. Souls, the board finds that, based on application for an attorney that you're indigent at this time, the board is Honorable John Manning, represent you, Mr. Mason County Court today, to reset you February 15th. Abraham is giving you information with Mr. Contact information, make sure you get in contact with him, maybe a day or so. Where that he's representing, paperwork into it. But make sure that you're in contact with him and back on February. All right, Mr. Fincher, come forward. All right, this is calling with CR 20-118, State versus Nicholas, Mr. Fincher. On a motion to adjudicate, Mr. Fincher, the court had placed you on community supervision and the states filed a motion to adjudicate, alleging that you violated conditions of community supervision. You have requested a court-appointed attorney, and the court has reviewed your request. It finds that you make sufficient money and you have sufficient assets that you could use leverage to get money to hire an attorney. So the court finds that under your financial condition that you're not indigent under the law. So at this point, you have two options. One is to hire an attorney to represent you in this matter. The second is that you can waive that attorney and then represent yourself if the court allows you to do that. In order for the court to allow that, I'd have to get information from you about your level of education, your age, your experience, those things. Before we start talking about representing yourself, and I understand that you indicated that you want to represent yourself, is that correct?
Yes, sir.
Before we do that, have you exhausted your resources in hopes and not hopes, really effort to try to hire an attorney?
Yes, sir. It's just been a rough couple of months, especially both dogs, because it's so cold and stuff. And my truck just broke down on the day that we were supposed to import, the day before yesterday. The bracket actually came off. The bracket that holds the alternator on came completely off. So I'm in a tight squeeze right now, but I think I'll just go ahead and represent myself because I honestly think it's just more of a miscommunication than anything with the Fannin County bond department. And that's what I want to do.
Understand that that may be your opinion, maybe your perception. It may not be what the other side's thinking. It may not be what the state of Texas is thinking. And so in order to make sure that you're adequately represented, even if you're representing yourself, you understand that there's a risk here that you could be adjudicated, convicted.
Yes, sir.
That once that conviction takes place, that stays with you for the rest of your life. It affects your ability to work, affects your ability to get loans, get licenses, including firearms, professional license, construction license, that nature. So it's very serious. Looking through your application, court appointed attorney, you indicated that you own land, is that correct?
Yes, sir.
Do you own that land free and clear?
Back taxes. I'm in the process of selling it right now. I do have a realtor. Yeah.
How long is the realtor for? So like
2 months now. I just recently dropped the house. So hopefully that does something.
if you were to sell that land, would you be utilizing any of that money to hire an attorney?
100%.
Contacted the attorneys to find out if there's any attorneys that are affordable for you based on what you have in saving, sell something, or payment plan, or credit card, or anything of that nature. Have you made any of those efforts?
I couldn't find an attorney that's less than 3,000. 3, 4, 5,000 for this.
Where's your land located? That's very big.
Yes, sir. It's in Fruitville, Texas.
Find out that you have sufficient intelligence, knowledge, experience, and might allow you to represent yourself. You do have a right to represent yourself if that's what you want to do. And the court finds that you're capable of representing yourself. Do you understand that you would be representing yourself against the state of Texas, who has licensed attorneys working the case that understand better than you the rules of procedure, evidence. They're skilled in arguing words. You understand that it would not be a fair fight. Understand that?
Yes, sir.
And you understand that, so the one that stands to lose the most, they do. Understand that? We're talking about your liberty, all the way from 2 years up to 20 years. Okay, that's a range. Okay, but it's a risk. That's something that you got to understand. You understand that even if I allow you to represent yourself, if you try to convey what you say is miscommunication, maybe what seems insignificant to you may not have the effect that you want. It may not accept it. If they don't, and we have to move forward, then the court's going to have to put that hearing. And during that hearing, it's going to be expecting to hear evidence regarding claims made by the state, made by you. And if that's where you're going to be anticipating, if you started studying today, you may not be able to level the blame. Does that make sense?
Didn't realize how big of a deal this was until you're kind of laying it out for me.
Yeah, well, that's my job, is to make sure that you understand the inherent risk. If Mr. Fincher, if this was a class B misdemeanor, and the most time that you can spend in jail would be 6 months, and I was able to understand that we only do a few days in jail, I would still give you these warnings, but whenever we get to felony imprisonment, incarceration, we're talking about significant deprivation of liberty. 2 years. 2 years is a long time. 20 years. The concept, right? So I want you to understand how serious this is. Before you say, no, I want to represent myself. So it's my job to make sure that you understand. And it seems like I'm trying to encourage you to be this, but that's what he is. Okay, you have the rights. My job to admonish you what your rights are. Right? I also encourage you to spend the time to make the government hear. Getting a loan against your land, selling your land, borrowing money, credit card, hiring an attorney, those things. Having an attorney on your side is going to be in your best interest. 10 out of 10 times versus you doing it yourself. This is not like tiling a shower, right? You get on YouTube, figure that out. You don't get on YouTube and figure out how to be assistant PA. Okay. So with all of that said, I can do a couple of things today. I can reset your case, give you time, try to get an attorney hired, try to move your land, borrow money, or whatever. I give you that. Or you talk about what it means to represent yourself, and I can ask questions about your age, your education, experience representing yourself, your knowledge of the law. Those are kind of the two options that we have. If you talk to anyone else, friend or family member, someone you trust about ways to figure out other options, how to get an attorney to represent.
No, sir. I've been kind of keeping this to myself. I really don't want to get any of my other family involved, but if I had a month to double down on selling my land, I can make that happen.
I think it's in your best interest. I'm willing to give you 30 days to do that. Because I think it's in your best interest. In those 30 days, if you don't get that done, you also need to plan Bs. You can't get that done. What else will you do? And I'm going to tell you, it's in your best interest to people you trust and see if they give you, if they may be able to understand how you can not sell your land. Just get a loan interest rate. Make sure you have that, but if you don't want to sell it, just take a look at someone they feel definitely have to life to get that. Have parents, have a lawyer, have a decent job. Honest to God, maybe wants to keep you out of jail, out of prison, they could give you some advice on, how to deal with some of those things. It's very neat. Land sold, said, money to use your money to hire an attorney, it's obviously a wise decision. So let's do this. Today is, I'm gonna give you a little more than 30 days, okay? I'm gonna bring you back on February 27th. It's just a little bit longer than 30 days. And so I expect you to work hard, because this issue is not gonna go away. Okay? And not gonna go away, basically, we have to get a resolution. Either we're gonna get a resolution to with an attorney, or we get a resolution. You as your own. Sure. So this needs to be very important. High priority for you next 30 days. Yes, sir. All right, thank you. Go ahead and sign that notice setting. All right, I believe that includes the document for Guild Shade 9. The lots of the file, A1719, for some brand dance, that all, I know we're going to issue outside. Get that done, I believe that does conclude the copy. So we can. Thank you, sir.